Legal appeals after Brexit. When the Brexit transition period ends on the 31st of December 2020, we will lose some of the legal protection offered by the Court of Justice of the European Union, CJEU. In any case, the CJEU isn't the only place disabled people and their organisations can take their human rights appeals for consideration. There's another framework, the European Convention of Human Rights, which will still be there after Brexit and which citizens will still be able to use if they feel their human rights have been breached. The bodies in charge of implementing the Convention are the Council of Europe and the European Court of Human Rights, ECHR, both of which are completely separate from the European Union. Legal experts are worried that the ECHR appeal process may not be strong enough to safeguard citizen rights at the same level they are now, because EU legal instruments and the EU courts have historically provided for stronger and more accessible enforcement. And seeing that the UK government has often hinted at its dislike for international courts and has previously stated its intent to remove the UK from European Convention on Human Rights, we may one day find ourselves out of the ECHR too. If that were the case, UK citizens would only have access to the UK domestic court system in order to uphold their rights, and would be entirely reliant on Welsh Government, UK Government and UK courts to drive forward progress. There would also be less oversight, as this is a function the EU and UN have long provided in this area. But what can we do to prevent this?
The UK has officially left the EU, so we will soon lose access to the EU's justice system when the transition period ends. However, many rights derived from EU law have been retained in UK law by the EU Withdrawal Act in 2018. So the work of DPOs will now be to ensure that these rights are not rolled back in the long term. In fact, many are keen that we go even further than that and that we keep pace with improvements that are introduced into EU law by introducing similar improvements in UK law, like the EU's Accessibility Act. Now, we're lucky in Wales that some of this can be done locally where, for instance, accessibility falls within an area of Welsh Government competence. I think we will need to be particularly vigilant in one area, however, as the UK Government has previously indicated its intent to remove the UK from the European Convention on Human Rights and the European Court of Human Rights. Now, these frameworks are completely separate from the EU, so we can remain members of them, and I think we must be very vigilant about this.
The issue of legal frameworks after Brexit is very technical, and it's likely to change quite a bit after the transition period. To get a clearer picture and to find out more, follow the links posted under this video in the description box. And if you have any questions about your rights after Brexit, reach out to us directly or through your local disabled people's organisation.